Good evening. Welcome back to Legal Talk, brought to you by the law offices of O'Donnell, Weiss and Megay, your life, your business, your law firm. My name's David Megay, and I'm one of the attorneys at the office, and I'm joined by Jim Kovaleski on my right, Joe Koury on my left, both also attorneys with the office. Folks, we're doing a little mini-series, if you will, about the corporate entity known as limited liability companies, or LLCs. And also on our website, the first phase, or the first show in the series, is talking about LLCs just generally, the background, where they came from, the pros and cons of them. Guys, this show we're going to talk about what Joe described off camera as ease of operations for LLC versus not having an LLC at all. Also versus the other popular corporate entity, S corporations. And then folks, I'd like you to click on to the next part 3 of the series, which will talk about the tax, which is these guys, that's bad English, but these guys' business, because they have the tax heads, I don't, but the tax consequences and how LLCs and S corporations work. So Joe, let's talk about LLCs versus S corporations, and just the general, what we call basic corporate formalities, bureaucratic, administrative structure, the pros and cons of each of the two entities.
Sure.
Yeah, go ahead.
Well, Dave, we talked briefly in the first part about the lack of formality, so to speak, with an LLC, and that really becomes apparent when you talk about an LLC versus a corporation or an S corporation. It doesn't really matter between those two in terms of the annual obligations to operate this entity.
Okay.
And by that I mean with a corporation, whether it's elected S corporation status or not, you have to have officers and you have to have directors, and they have to meet and shareholders, and the directors and shareholders have to meet annually, even if it's on paper, so to speak. And that's a requirement, these annual ongoing meetings of shareholders and directors to maintain that corporate status.
And lenders require copies of those minutes occasionally, don't they?
They do.
When a lender is loaning money to the S corporation.
Correct.
Okay.
And more to the point of this program, any good plaintiff's attorney is going to say, well, let's see some minutes here. How do we know that this thing has been operated correctly?
Right. Right.
Which unfortunately, it's often overlooked in my experience, the annual meetings.
Sure.
Because most corporations are what we call closely held.
Right. In other words,
publicly traded. They're not on the NASDAQ or some other exchange. It's just a family business, so to speak. So that's the last thing they're thinking about. Right.
Right. Jim, Joe mentioned corporations versus LLCs, but aren't limited liability companies, LLCs, technically corporations under Pennsylvania law? They're a separate entity, aren't they?
They are. So they're treated as a separate entity. That's why you get the personal liability protection.
They get their own tax ID number. So it's James C. Kovaleski, Esquire. You have your social security number ending in 1234 or whatever.
Yep.
If you form James C. Kovaleski Inc. or James C. Kovaleski LLC, you wouldn't use that social security number 1234, would you?
Actually, you could.
You could. Okay, good.
With LLCs, you could if there's only one member. But to your point,
preview to the tax piece.
Exactly.
There you go. So you need to click on the third part of the series.
But usually, you will get your own EIN because you'll be opening up a bank account using that EIN. And again, we're going to keep hammering it, following those corporate formalities and doing what needs to be done.
Okay, Joe. I hear the term manager or member managed when it comes to LLCs. What's that all about?
Well, before we talk about that, I'm happy to talk about it. With the LLC, you don't have the ongoing annual meetings that I mentioned a moment ago. So it's much more relaxed, if you want to think of it that way.
So if I form my own LLC, I don't have to have annual meetings with myself.
Correct.
I don't have to.
But you should still document particularly if there's more than one member, meaning
Yes.
the owner of the LLC.
Okay.
You should still document, and it can be loosely documented, but still document major decisions. If you go out to buy a piece of real estate, it'd be great to memorialize that you and I, as the members of the LLC, agreed to purchase 123 Main Street for
Okay.
$500,000.
Okay.
Whatever.
So S corporations have shareholders, LLCs have,
Members.
and both shareholders are the owners, members are the owners.
Correct.
Okay.
And with an LLC, by default, management of the LLC is through its members. So any one member has the ability to go out and bind the LLC, even without the other members' consent. In that way, it's kind of like a partnership. I said
Okay.
a few minutes ago, an LLC is like a corporation. And it is, in the sense that it gives you liability protection, but it's also like a partnership. 'Cause it's incredibly flexible, particularly if it's a member-managed LLC.
Okay.
In the sense that any member, if you want to think of them as a partner in a general partnership, can do the business of the LLC, can bind the LLC.
Okay.
Contrast that with what we call a manager-managed LLC, where one person, or more than one, but typically one, designated as the manager, has typically exclusive authority to administer the affairs of the LLC.
Okay, so the three of us form an LLC, but we agree that I'm the manager,
Yes.
meaning I have sole discretion over.
You're the king, so to speak.
Okay, okay. All right, good, good. Now, if the three of us form an LLC, don't we need some kind of an agreement? And what's that agreement called?
So under the law, you're not required to have one, but we
Okay.
always recommend if there's more than one member, or even if there's only one member, you have a operating agreement. So that's the agreement by and among the members that defines their rights, roles, and responsibilities as members and potentially as managers to the LLC. So it tells you what happens if you want to sell your interest or if you pass away, or what kind of vote is required to authorize one of the members to sign on behalf of the LLC. All baked into one document, the operating agreement.
So, folks, if you have an LLC and you're the sole owner, please talk to your attorney about getting an operating agreement. The three of us do a good bit of real estate transactions, and yeah, that's the way to say it. And the lenders always ask for, and when we're also agents for the title company, the title company needs a copy of that operating agreement. So folks, when you form that LLC, please get an operating agreement right from the beginning, even if you're the only owner. Don't wait until asked for it, because then it becomes a little bit of a clown show at the end trying to pull it all together. Is that a good way to say it? Because with a shareholder, with a S corporation, you need a shareholder agreement, even if you're the sole shareholder. So please get it done, and don't rely on LegalZoom or any of those other canned websites, because oftentimes those sites aren't Pennsylvania law compliant, etc. Well, guys, thank you again for, we could talk for hours on this, but we only have a minute. Thanks again for joining me. The first half of this three-part mini-series was talking about LLC background. That we just talked about LLC ease of operation versus LLCs versus S's, LLCs versus individuals. Folks, I want you to click on the third phase as soon as you get a chance. We're going to talk about LLC tax consequences. So Joe Koury, Jim Kovaleski, joining Dave Megay here. We're O'Donnell, Weiss & Matei Law Offices. We're at www.owmlaw.com. Your life, your business, your law firm. Thank you.